Newspapers provide us with information. I keep telling them, keep up the good work. It's fundamental to democracy. Thank you very much, Mr. Speaker.
Minister of Justice.
Thank you, Mr. Speaker. Today I'd like to contribute our government's position on this important debate on Bill S-231, the Act concerning the protection of journalistic sources. This is a question that interests all Canadians. As this debate is taking place at a moment when media are being attacked in certain regions of the world, it's important that we highlight the essential role that they play in protecting our freedom and our democracy.
Last October, it was made known to the public through the media that several media outlets and journalists were the targets of police surveillance in Quebec. Although a journalist, just like any other Canadian, can be the subject of a criminal investigation, what the public and parliamentarians were most concerned about was the possibility of the media being surveilled in order to identify their sources in a context where it was not evident that the criminality of the journalists was in question. It is clear that such conduct is profoundly troubling, as it has a potential chilling effect on the willingness of whistleblowers to come forward with their stories. Whistleblowers are often the only source for uncovering systemic corruption and other issues that undermine our democracy.
Following this incident, the government of Quebec reacted quickly and amended its guidelines and measures to protect and protection measures concerning concerning warrants and journalists. The government of Quebec brought together lawyers, judges, and members of the National Assembly, and who already benefited from additional protection, and included journalists in that protection when it comes to acquiring a warrant. The government has also, in Quebec, also set up a commission to study this issue, and hearings should take place between now and the end of the month. Following these events, two bills were tabled in Parliament on the issue of protection of journalistic sources. Today, we are debating the bill proposed by the Honourable Senator Claude Carignan, which is led in the House by my colleague across the way, the member for Louis Saint Laurent.
Sources are given due consideration whenever they are at issue in Canadian courts is indeed laudable, Mr. Speaker. This initiative transcends political lines. On that note, we would like to thank Senator Carignan, as well as all the other senators who worked so tirelessly and passionately on this important bipartisan initiative. That is why we are proud to support Bill S-231, all the while proposing certain amendments that will not only address certain legal and policy concerns that have been voiced, but to help it better meet its objective. L'importance du sujet est évidente.
It's clear that this subject is very important. However, it's also important to note that law and rights for confidential sources is very complex. The current laws have been studied by the Supreme Court of Canada in a context similar to the issues focused on by the bill we're debating today. Right now, the protections that journalists and their sources have under the law have been confirmed under common law. So in this context, that's the jurisprudence which interprets the freedoms granted by the Charter and the legislative framework under the Canada Evidence Act and the Criminal Code.
Parliament enacts laws. It is codifying strict practices that will frame an issue and, as a result, supplant the common law. This is why it is important that whatever legislative change we enact in the name of journalistic protection, it must further protect journalists and their sources and not weaken them. In relation to the Canada Evidence Act amendments, the bill seeks to create a unique regime applicable anytime the media wish to protect a journalistic source. However, there are some problems relating to this new regime. In Clause 2 of the bill, which is proposed under subsection 39.1 sub 8, one of the factors listed under paragraph B is the, quote, essential role of the information or document to the proceeding. Our government is concerned that the reference to the word essential could impede the administration of justice in some cases, as it may be unknown at the outset of a proceeding whether a piece of information or a document is essential. Requiring consideration of the importance of the information or document would still be within the spirit of the bill, but would provide the court with greater latitude to make its determination. Next, the new condition that was added by the Senate at committee, paragraph 39.18 sub c, is a valuable addition. Due consideration should always be given to preserve the identity of the journalistic source, even if a document is admissible. This condition will always be met, which will weaken the privilege. As such, our government believes that this new condition should be moved to a separate section, such that it is not a condition of admissibility, but rather a step the decision-maker must undertake once information is admissible. This is expected to strengthen the protection of journalistic sources. Finally, the bill proposes an override provision that would give the provisions of the bill supremacy over any other provision of the Act or any other Act of Parliament. This provision is not only unnecessary for the proper operation of this new scheme, but it raises significant legal and policy issues. It is wholly unclear how this override would affect other laws, including those that relate to privacy and national security. As Parliament believes that every law it passes is important, override clauses should be used sparingly.
When it comes to the proposals which affect the criminal code, it's important to know how all the tools, such as search warrants and production warrants, can be delivered and executed when they target a journalist. While the goal of these proposals and of the bill is to protect sources, the procedure proposed by the bill would apply as soon as a journalist is targeted by any investigative tool, even if that journalist is the subject of a criminal inquiry. The bill also proposes a triage procedure, which would require that any evidence acquired be locked away and that it be evaluated by a tribunal before it is divulged to the police. It's also important to note that the bill also suggests that Superior Court judges can authorize the use of an investigative tool when it concerns a journalist.
The government is of the view that these proposed criminal code amendments raise some discrete legal and policy issues. The fact that the new regime would apply even in cases where a journalist is suspected of criminal activity was a major concern of Senator Vernon White at the Senate committee, and our government remains concerned that it was not adequately addressed by the Senate. Our government does not suggest that a confidential journalistic source should lose his or her protection in this context. As such, we propose that the additional conditions for the attainment of a warrant would not apply in cases where the journalists themselves are suspected of criminal activity, but the sealing order provisions would still apply to protect the source. The other policy question arises because the new regime seems to apply each and every time a journalist is implicated, even when the police are not aware that the target is a journalist. Our government does not believe this was the intention of the bill. The fact remains that it could lead to court challenges where police subsequently discover they are investigating a journalist but were not aware at the time of the application. Making it clear that the regime would only apply when the police knew or reasonably ought to have known that the target is a journalist, and creating a process whereby the police could inform the court when they become aware that the target is a journalist would make the scheme much more workable. Lastly, the bill also provides for an override clause with respect to the criminal code provision. This is not a situation that needs an override clause yet there is the real potential for conflicts with other acts. Most notably, it would prevent the police from acting in exigent circumstances, which may include ongoing terrorist activities or attacks where the perpetrators use the media to increase their exposure. Mr. Speaker, I ask all the members in this chamber and in the other House to support this bill for all of the reasons that I've identified, as well as the amendments our government is proposing to improve upon it. Merci, Monsieur le Président.
Thank you, Mr. Speaker.